Hi, very good morning. This is a judgment of Supreme Court under consumer protection. Yash Raj Films Private Limited versus Afreen Fatima Zaidi and another. Very, very interesting case. Facts of this case. All of us know Yash Raj Films is a film producer. Hereafter, I will call him as YRF. It produced a film called Fan. Before the release of the film, a teaser was circulated both on the television and also on online. That teaser contained a song in the form of a video. The Afreen Fatima, that is she was a teacher. Hereafter, she will be mentioned as AF or teacher. She watched the teaser, that is the promotion of that film. She decided to go to the movie and watch the film because some song was there in that teaser. She was so impressed with that song. So she went to that movie and bought the tickets. Along with the family, she went to that movie and got the tickets. That in that movie, that song was not there. The song which was there in the promotion of the film or the teaser, that was not there in the movie. Immediately, she went and filed a consumer complaint. The District Consumer Forum dismissed the complaint on the ground that there is no relationship of consumer and service provider. She appealed to State Commission. State Commission held that it is an entertainment service. There is deficiency in service and unfair trade practice adopted by the film producer, that is YRF, Yash Raj Films. State Commission awarded compensation for mental harassment and also cost. YRF, the film producer, filed appeal to NCDRC. NCDRC held, that is National Commission, held consumer would feel deceived if a song shown in the teaser or promotion is not played in the movie. This is an unfair trade practice and also amount to deficiency in service. So they confirmed the judgment of State Commission. Then the YRF approached the Supreme Court. The issue was whether the teaser would create a contractual relationship or any other right or liability. Was there a deficiency in service? Second, is it an unfair trade practice? That is the third question. These three questions were before the Supreme Court. Supreme Court said a promotional trailer is an advertisement for film. It is a settled position of law that a commercial speech, which includes advertisements, is protected through freedom of speech. The same is excluded from constitutional protection only if it is deceptive, unfair, misleading, and untruthful. Then Supreme Court says an advertisement is not only informational but also a means of creative and artistic expression. Advertisements build brand royalty and reputation. They promote an image and ethos of not only the product but also the manufacturer or service provider. A promotional trailer could be used to popularize or to create a buzz about the release of the film rather than to purely represent information about contents of the film. Supreme Court said there is no doubt that any person watching a movie after remitting the necessary consideration becomes a consumer of service. There is no doubt. The service is an entertainment service. But whether this will amount to deficiency in service, Supreme Court said the submission that a promotional trailer is an offer or a promise is a fallacy. Supreme Court says that a promotional trailer is unilateral. It is only meant to encourage a viewer to purchase a ticket to the movie, which is an independent transaction and contract from the promotional trailer. A promotional trailer by itself is not an offer. I neither intends to nor create a contractual relationship. Since there is no offer, there is no possibility of it becoming a promise. Therefore, there is no offer, much less a contract between the parties to the effect that the song contained in the promotion would be played in the movie, and if not played, it will amount to deficiency in service. The transaction of service is only to enable the viewer, that is the AF in this case, the teacher, to watch the movie upon payment of consideration in the form of purchase of ticket. This transaction is unconnected to the promotion, which by itself does not create any kind of right of claim with respect to the content of movie. So Supreme Court says there is no deficiency in service. It is not creating a contract. It is the promotion is only just to impress the viewer to come to the movie. You cannot consider it as an offer, and then they are entering into a binding contract. It said no, there is no deficiency in service. Then the next question was whether there is unfair trade practice. Supreme Court says it is a settled position of law that to constitute unfair trade practice, a false statement that misleads the buyer is essential. A false representation is one that is false in substance and in fact. Further, statements of the nature which are willfully made knowingly false or made recklessly without honest belief in its truth and made with the purpose to mislead or deceive will definitely constitute a false or misleading representation. A failure to disclose a material fact when duty to disclose that fact has arisen will also constitute a false or misleading representation. Supreme Court held the ingredients of unfair trade practice are absent in this transaction, and the burden is also on the viewer, that is the teacher, AF, to prove which he failed to prove. Supreme Court allowed the appeal and set aside the orders of NCDRC. My comments. The revenue of Yash Raj Films for the year ended March 30, it is approximately nearly 1500 crores. The amount in dispute was the State Commission awarded 10,000 rupees for mental harassment and 5,000 rupees for cost. How much precious time of court is wasted in this case? District, that is 10,000 plus 5,000. Person who is filing the case is Yash Raj Films, 1,500 rupees revenue approximately. District Forum, State Commission, NCDRC and Supreme Court. All of them are working for 15,000 rupees, deciding 15,000 rupees case. I am not including the work or the effort put in by clerk, advocates and others. Point number 3. Government. Today the government has decided not to contest the cases below a certain limit to reduce the burden on courts. Income tax also, that circular is there. GST also, that circular is there. Is this worth consideration by Supreme Court? 15,000 rupees case, consumer case. A petty sum of rupees 15,000, that too for a film producer like Yash Raj Films, who must be spending some 2,000 crores for making a film and paying 150 crores to the actor. Is that worth? Instead, Supreme Court could have taken up many important cases which is waiting for its consideration. That is point number 3. Point number 4. It is not a recurring issue. Suppose it is going to come again and again, or it is an issue of national importance. So Supreme Court, even though the amount is small, the issue is national importance. Or it is a reputational issue for the company. No, this will affect my reputation. Then I can understand. I am seeing, unfortunately, many cases of this nature are argued before Supreme Court, wasting its precious time. And judgments are running into several pages. Fifth point, Supreme Court must keep this in mind. It is serving 150 crore people of a great nation. I think there are only 34 Supreme Court judges are there. 150 crore people. Every day, people are now becoming intelligent. Every day they are filing cases. For anything, they are saying, we will meet in court. That is what people are saying. So 150 crore people, only 34 judges. Will it not become penny wise and pound foolish? Supreme Court must introspect, is my humble suggestion. Finally, I am extremely sorry for wasting your time on this judgment, 15,000 rupees judgment. But this judgment is interesting. That is why I shared. Thank you very much. Have a great and wonderful day.